No. Well, she take one half of the husband's one half. Okay. The husband share the community property. What's the husband share the community property? One half. One will surviving spouse, one will wife take one half of that. What circumstances? 1 second. 15 seconds. All right, Mr. Brand, under what circumstances? Never. Never. That's exactly right. Under the intestacy statute, never. That will never happen under the intestacy statute.
Did you specify that he had to die intestate?
Yeah, I said intestate. Intestate. That's right. I mean, if he didn't die intestate, if there's a will, you see what the will says. Exactly right. Okay. Now, keep this in mind. There's a slight twist that people get confused on this when we get to pretermitted children, but don't worry about that right now. We'll talk about that much later in the semester. But right now, husband and wife, community property, husband dies, survived by the wife. Mr. Brand, problem number 1, husband dies, survived by the wife. I forget. It's easy for me to forget. I'm getting old. But I remember that you were up on Thursday. Okay? And we were doing problem number 1. We were in the middle of problem number 1. And husband died, survived by the surviving spouse. All those descendants, children and grandchildren, are also the descendants of the surviving spouse. Well, decedent died. We don't know, right? It could be wife died, survived by the husband. Look at the example of giving husband died, survived by the wife. Okay. Where does the community property go and why? All the community property, all the couple's community property. Where does wife's one half go? Wife keeps because death dissolves the community. Now, by way of inheritance, that was hers anyway to begin with, her undivided one half. Husband's one half goes in problem number 1 to wife. 100%, all of it, not half of it, all of it. The statute just doesn't seem that clear necessarily, but that's it, all of it. She takes all of his one half if all of these descendants are also her descendants. We'll see the variation in problem number 1A and 1B. Okay, that's the review. That's where we left off on Thursday night, right? We're in problem number 1. Now let's talk about the separate property. Now row number 1 is on call. You can pass this off now if you want to, or you want to pass it off. You don't care. Okay, let's see if we got any volunteers here from row number 1, which was the on call row. Anyone want to
Which
take
question
problem
was it?
number 1?
Oh, problem. Well, okay.
The separate property. Is there a difference between the way the separate real property passes in problem number 1 and the separate personal property? Yes, there is. Okay, so you're going to have to read different subsections of the applicable statute. So, who wants to take problem number 1 as to the separate property, real and personal? Okay, okay. You want to do the separate personal property first or separate real property?
Well, I have real property first. So
you can do the real property first. Well, you can do it. I mean, that's the harder one. The separate personal property is much easier. But you can do the separate real property first if you want to. Now you're giving me a look like, oh, crap.
I've done it. So
You done both of them, right? Yeah. So
just give me the answers. Right?
give me the answer. Give me the answer in any order you want to give me the answer. Because if this came up on the final exam, you can give it to me in any order. I don't care. So long as you explain it properly, I don't care which order you give it.
Personal, since you were.
No, we can do the real. No, the personal is just a little easier. But the real, we'll do the real if you want to. Do the real.
Real property is surviving spouse.
Okay, separate real property. What statute are we in? What statute were we in for community property?
201.003.
201.003 for the community property of the decedent, the intestate decedent. And what section are we in for the separate property of the decedent?
201.002.
We are. We're in 201.002. We're in subsection A tells us if a person who dies intestate leaves a surviving spouse. Oh, that's the situation we got right? The estate, other than the community estate, the estate, whose estate? What estate are we talking about? The estate of the intestate decedent, in this case, is D. We're going to assume it's a husband. And the estate, other than the community estate, so what does the word in subsection A, estate, mean? If it's over in the community estate, that must only mean what? The separate property. The separate property estate of the intestate decedent, to which the person had title, that's the decedent, descends and passes as provided by this section, and this section, we got slightly different, a different way for it to pass in subsection B as opposed to subsection C. Are we in B or are we in C? We're in B.
That's exactly right.
Problem 1, actually we're going to see problems 1 through 4. We are in B. Okay, well, no, not always. Okay, problem 1, 1A, and 1B, we're in B. We'll see where else we're going to get past that. All right, so if the person has one or more children or a descendant of a child who survived that person, who survived D, then we're in subsection B. And what you want to do the real property first? What subsection or subsections are we in? We're in B3 for the separate real property. We're in B3. 201.002 B3. Where are we for the separate personal property?
002 B1.
Okay, B1 and B2, exactly right. Okay, B1 and B2 for the separate personal property and separate real property, which is a little harder to insist on doing first, and that's great. God bless you. Thank you for being so intrepid. We're in D3. So let's see how the separate real property passes. Because remember, I told you in the instructions to assume that this is equally divided. Separate property is equally divided between real property and personal property. Okay, so separate real property passes now. Under B3.
Describing spouse gets 1/3 life.
1/3 life estate. Oh gosh, that's that 1/3 life estate. We talked about why that might be significant. A 1/3 life estate with the remainder descending to the person's child or children and the descendants of a child or children. Okay, I want to parse that language very carefully. With the remainder. What does that mean? What does that word remainder mean? Okay, so let me just ask you this. So SS, in problem number 1, gets a 1/3 life estate in separate real property. Okay? It's the rest of it. Remainder. What does the word remainder mean? What does this word, you remember, you had a great professor for property. I know him, I like him. Okay, all right. And what did we say the word remainder meant? It had a technical estates and land and future interest term. What's a remainder? And is this statute referring to that kind of remainder, or does that word remainder mean something else? Something other than technical legal term. What's a remainder? Well, leftover, right? And, give me an example of the kind of present possessory estate that a remainder would follow. A life estate, exactly right, okay? So, we could say that this remainder means remainder in the technical legal sense. If it meant remainder in the technical legal sense, what would that distribution be? And once we see that distribution, we know it's equal to remainder in the technical legal estates and land and future interest sense, even though these are general life estate, which can be followed by remainder. It says, with the remainder descending to the person's child or children and the descendants of child or children. We'll talk about what that means in a moment too. But the remainder. So, if this were the remainder following the life estate, where would that go? Which children? Which children?
Which children?
Specifically.
Oh, okay. And
No problem.
child 1 through 3 takes the remaining.
Child 1, 2, 3. 1, 2, and 3 would take the remainder. What remainder would that be? If it were would it be vested? Would it be a contingent remainder? Would it be a T simple absolute? Would it be otherwise? Now remember all this stuff from first year property? Remember I said the very first night of this class that I'm not going to test you on estates and land and future interest. The bad news is it's the basis for so much of what we do here. I expect you already know it. So I'll test you for things beyond that, and this is one of them. So what does that word remainder mean? It does. It means the balance. It means the rest. If this meant remainder in the technical sense, and I know, I'm sorry, this board is so messed up. It's so hard for you all to see it back there. I apologize. That's why I'm going to call out what I'm writing on the board. Surviving spouse takes a 1/3 life estate and a separate real property. That's clear under subsection B3. That's clear. remainder means balance. If the word remainder meant vested remainder, let's just play that one out. Let's suppose that it meant vested remainder in the technical legal sense, remainder, like a remainder after life estate. Then C1 through C3 would each take a vested remainder in fee simple absolutes. Vested because we know they are, and it's not subject to any contingency, right? I mean, the statute doesn't say they only take if, under certain circumstances, they're going to take. So it's vested remainder, but there's a 1/3 life estate. That would be a 1/3 vested remainder. Each of them would take their share of that. There are 3 of them, so each of them would take 1/3. There are 3 of them. 1/3 times this 1/3 vested remainder equals. Each one would have a 1/9 vested remainder in fee simple absolute, following mom's 1/3 life estate. Wait, let me finish before you start asking questions. Okay? All right. Where will the rest of it go? Is that everything? Has that disposed of everything? If remainder means remainder in the technical sense, there's a 1/3 remainder following the 1/3 life estate. Where does the other 2/3 go? And what is the other 2/3? What's the other 2/3? See, that's why I asked you if you want to do the personal property first. Because you're giving me this horrified deer in the headlights look. And you may have gotten it right. What? The balance. It is the balance. It is the balance. So it can't mean this because we've left some of the property disposed of. So that word remainder in the statute doesn't mean remainder in the technical legal sense. It means the balance, the rest of it, the residue, whatever. Okay. So where does it all go? Do I throw this out? No, I don't throw this out at all. This is part of it. This is part of the answer. This is easy and simple, straightforward. You have to be a moron not to understand this. No, it's horrifying. This is horrifying. This is terribly drafted. This isn't what the average intestate decedent would want or would expect. Let's spin this one out, and then you tell me how you're going to explain this one to your client. Okay. All right. So, no. We don't throw this out. This is it. Each one, surviving spouse takes a 1/3 life estate. These children, as a group, we'll figure out what the shares are in a moment, will each take a 1/3 vested remainder following that 1/3 life estate, and now we divide it up. There are 3 of them, each takes 1/3 of that 1/3 vested remainder. So each one takes a 1/9 vested remainder in fee simple absolute, plus, not finished. Where's the other 2/3 of the estate? We have 1/3 life estate. Where's the other?
The other 2/3 of the estate.
Okay, the other 2/3 are divided amongst the children. So each child takes 1/3 times the other 2/3. That means 2/9 of what? Of what? 2/9 of what? Of the other. That's what that we disposed of the other 2/3 of what? Not a life estate. If it's a life estate, we haven't disposed of everything. It's fee simple absolute. So here's what we're left with. Okay. This is the right answer on the final exam when it comes up. It will come up in some form or fashion. It may come up a lot on the final exam. Here's the right answer. For the separate real property for the intestate decedent under 201.002B3, surviving spouse takes a 1/3 life estate in the separate real property. 1/3 life estate. What happens to her interest when she dies? Dies with her. Right? It's only a life estate. And right now, in this case, the children, in this case there are 3 of them, there are 1 who've been divided 3 ways, take both their share of a 1/3 vested remainder in fee simple absolute and their share of a present possessory 2/3 fee simple absolute. We just figured out how the shares are divided. Right? So if there was only 1 of them, they would take a 1/3 vested remainder in fee simple absolute and vested remainder in fee simple absolute and a 2/3 in fee simple absolute right now, the present possessory estate, which now that's we disposed of everything. 1/3 life estate plus 2/3 fee simple absolute. Fee simple absolute, that's everything. 1/3 life estate and 1/3 vested remainder in fee simple absolute. You put that all together, we've got everything. Put that all together, they spell mother. Now put that all together, they spell their mother, right? That's everything. Easy, simple, straightforward. Try explaining that to your client. Do you think that's what the average intestate decedent would expect? Do you think that's what the average intestate decedent would want? What do you think the average intestate decedent would want? Do you think you want the surviving spouse to take a 1/3 life estate? I don't think so. Maybe a 100% life estate with the real remainder for these kids, maybe everything, I don't know, but not a 1/3 life estate. That's ridiculous. But there it is. Now, questions about this. We haven't gotten to the personal property yet. Questions about this? This is easy. This is simple. This is straightforward. No, I know. We can do me. Questions about this?
So just confirm each child gets 2 nights.
Each child gets 2 nights in fee simple absolute plus a 1 night vested remainder in fee simple absolute. This is each child's share. Their fractional share of the vested remainder on 1/3 life estate, and their share of the other 2/3, which is in fee simple absolute right now. Right? That's it. That's the answer. Other questions about this before we get to the personal property, which is easy. Okay, the real property is not the personal property.
She asked me just a second ago,
Sure.
should they be joint tenants with the mother or tenants in common?
They'd never be joint tenants, and we'll see later on. Joint tenants for survivorship, never, under any circumstances, in intestacy, they would only be tenants. Okay? And you'll see why later on in the course when we get to, a little later on, we get to the joint tenancy with right survivorship statute. No, I'm not saying, oh, you idiot. No, I'm saying, no, it's a good question. It's a perfectly good question, okay? In Texas, I'm just going to tell you, in Texas we have a statute, and generally, you have to create, a joint tenancy with right survivorship can only be created, it's not what you learned in first year property, it can only be created by an agreement among the joint tenants, expressed or implicit, to hold the property as joint tenants with right survivorship. Where would that agreement be? Well, it doesn't come in statute, they're tenants in common. Later, after they get it, they could say, and now we agree to hold it as joint tenants with right survivorship. That'll never happen in this class. That would be your first year property class. But we'll talk about that statute when we get to it. Okay. Good question. That's a good question. That's a good question. Very good question. All right, what else? What else you got? Now let's talk about the personal property, which is much easier. But this is hard. This is confusing. This isn't exactly, I think, what the average intestate decedent would want, but this is the way it is. We'll continue to work, problems 1A, 1B, 2, 3, and 4 will be some variation of this. All right, how about the separate personal property? Use a different color. What do we do with the separate personal property? Where are we? We're in B, subsection 1 and 2. Where does that go?
Surviving spouse is 1/3.
And then,
Children 1 through 3.
and the children get the 2/3. So the surviving spouse gets 1/3 to the life estate. It's just outright. It's just outright in separate personal property. And the children, C1 through 3, each get
1/3 of the remaining, which is 2.
each get 1/3 because there are 3 of them. And what remains? 2/3. 1 times 2 equals 2. 3 times 3 equals 9. You laugh. You don't know how often I have to count off, and I will if you don't get the fractions right. Okay, that's why I'm going so slowly, because on the final exam, when you're under pressure and you miss that, I say, thank God, someone missed it so I can have my nice curve. I don't want any of you all to miss it. That's why I'm taking this time here right now. Okay. All right. So each one of these gets 2 nights in the separate personal property. Right now, it's not in life estate, it's not in trust or anything like that. All right. Question about that. So far. Okay, let me ask you this. Mr. Rumko, let me start with the statutory language. Just this. Let's look at 201.002 subsection, and this is in a lot of the statutes. This little interpretation conundrum. Look at B2. 2/3 of the personal estate descends to the person's child or children, and the descendants of the child or children, and the descendants. Now let me ask you this: C1, 2, 3 have their own children. They have their own descendants. Does that mean the children and grandchildren somehow share? That's what a literal reading of that says, doesn't it? And when we're in subsection 3, it says the same thing. With a remainder, we already know that's not a remainder. We know that means the balance. Descending the person's child or children and the descendants of a child or children. Is that word "and" in this phrase that we see a few times in these statutes really mean and, or does it mean something else? Does it really mean and to the descendants of a child or children? It does depend on the surviving. The word and doesn't mean and. The word and really means or. Follow along with me in 201.002 subsection. Let's try B2. 2/3 of the personal state is sent to the person's child or children. Here's what it means. Or to the surviving descendant of any child or children, any predeceased child or children, any child or children who have predeceased the intestate decedent. That's what it means.
Are they using it much like what we learned in property, the term heirs, where you have heirs and pass away, or using
I don't. That's a good question, but I don't think so because in fact this is where these are the statutes that determines now the person's died intestate and here are the heirs. So I think what it really simply means is to determine the heirs, it goes to the children if there are any children, and if any child has predeceased, it doesn't go to that child. Alternatively, it doesn't go to that child. It goes to the surviving descendants of any predeceased child, any child who's died before the intestate deceased. That and the descendants of a child or children, that really means or to the surviving descendants of any predeceased child or children. That's what that means. And you knew that. I mean, your just gut told you that. But that's not a literal reading of the statute. A literal reading of the statute makes it look like somehow they are tenants in common, the children and the grandchildren. Oh, no, they're not. It just means the grandchildren, or the great-grandchildren, the descendants of any predeceased child are substituted for that child. They'll take first or okay? So, let's see what else I want to say. Question about that? Okay. By the way, how do we know each one, how do we know each of the children took 1/3 of whatever share? 1/3 of the 2/3, 1/3 of the 2/3, 1/3 of the 1/3. They each took an equal share. How do you know that?
We know that they did or that they.
That they will. That's what they're going to do, that this is in fact right. There's another statute we haven't talked about, right? Remember, 201.002 and 003 tell us who take, but there's another statute that tells us how those shares are divided. 002 and 003 tell us how the surviving spouse's share is divided. How about the children's share? What statute applies there? No, it's on B2. It's not here. It's elsewhere. It's close. It's nearby. It's nearby. Where is it? Where are we looking? See, I could be making all this up. I want you to see that it's right here in the statute, that I'm not making this up. I couldn't make it up if I wanted to make it up. Right? This isn't how I would make it up if I were making it up. 201.101, exactly right, 201.101. Okay, so let's go back and look at 201.101. Determination of per capita with representation distribution. Look at subsection A. And let's read along in pertinent parts. The children, ... who stand in the first degree of or the first ... degree of relationship alone, and come into distribution of the intestate estate, take per capita, which means 5 persons. There are 3 of them, each takes an equal share. Okay, that's it. We're in subsection A because all of them are standing in the first degree. They're standing in the first degree. How do you know they're standing in the first degree? Page 4 of your case book, table of consanguinity. First degree of consanguinity. In the case book. Look at page 4, look at the Altschuler chart. Easy to read. Look at the decedent, right there in the middle of the chart. Where are the children? Physically on that chart, where are the children? Immediately beneath the child, the decedent, and that's what we've got here. C1, 2, 3 are immediately beneath the decedent. And what degree of separation are they? Look at look at the number. One, they're in the first degree. They're the most closely related. But the parents are also in the first degree as well. You count, if we're talking about descendants, you count up to the common ancestor. Who's the common ancestor for all these children? Dad who just died. How many steps are there between him and dad? That's it, just one. They're in the first degree. Okay, so they are in the first degree. Let me ask you, if all the grandchildren took, and we'll work those problems a little later on this evening, unless I'm just so slow that we don't work them until Tuesday. But I hope we'll work them tonight. If all the children were dead and the grandchildren took, what degree? Don't tell me what shares it's divided into. What degree? Would they be in the same degree? All the grandchildren took. No children. Will they be in the same degree? They're in the same degree. And what's that degree? The second. And how do we know that? You can see that on the chart. But you can shut the book and not even do that now because I've told you what to do. How do we determine the grandchildren in the second degree? 1, 2. Count up to the common ancestor who just the state we're distributing now, right? 1, 2. It happens to be the state we're distributing. Grandchildren are 1, 2, 2 degrees separated from grandpa. How about great-grandchildren? How many degrees separated would they be? 3. Great-great-grandchildren. 4. Okay, you 6. You understand that. But what about other siblings? What about descendants? Siblings? We're not talking about that.
What about parents?
We're not to parents yet either. Okay. Mom and dad happen to be in the first degree also, but,
Yeah,
but we're not there yet.
Okay.
We'll talk about that in a moment. When mom and dad. Okay. I'll get ahead. Okay. No, that's a good question. We'll get to that. All right. So, let's see. What else? Questions about that? All right. Let's talk about something else. Oh, I asked, how would your answer be different in this problem? I asked that in all of them, in problems 1 through 11. How would your answer be different, if at all, if dad, husband, decedents, parents and siblings, or descendants of siblings, also survive? How would that change your answer in problem number 1, if at all? Would it change your answer at all? No, it wouldn't change your answer at all. We'll see where it does change your answer later. And we're in subsection C, but we're not in subsection C yet. Okay, subsection C. All right. Now I want to talk about homestead rights. Let us suppose that when D died, he has separate real property. We know that. We already talked about the fact that the directions tell you to assume he has some separate real property. What if these separate real property includes the marital homestead, the property where husband and wife, surviving spouse, right? The husband and wife were living immediately before husband, the decedent's death, and which was owned by husband as his separate real property. It was owned by his separate real property immediately before husband died. What was wife's ownership interest in that property? Immediately before husband died, it's husband's separate real property. What's wife's ownership interest in that property? Nothing. Doesn't own any of it. It's his separate real property. Good question. By definition, it's a separate property. She doesn't have an interest in it. Okay. But she dies. Or he dies. Excuse me. He dies. He dies intestate. So, just immediately after he dies, it's a separate real property. What's her ownership interest in it? It's a separate real property. What's her ownership interest? 1/3 life estate, right? It's right here on the board. Okay? 1/3 life estate. What are her homestead rights? What are her rights to continue to occupy that property, despite the fact that she doesn't own 100% of it outright? Be simple absolute. She only owns a 1/3 life estate. I want to talk about that for a moment. I want to go to the session. A number of you have taken marital property, and how many of you have taken marital property? A good number. You talked about this particular issue of homestead occupancy rights upon the death of an intestate decedent or death of a decedent. A little bit. Okay, a little bit. Okay, you've had at least an introduction. Now you're going to get a lot more of it. Perhaps more than you want, but perhaps it won't be any more than you want come December on my final exam. Is that a broad enough hint that sometimes I ask about the surviving spouse's homestead occupancy rights? If I do, here's the answer. Pay attention. We'll spend the next 5 minutes talking about that. Now, there are different questions that we have to answer in connection with the homestead. First question is ownership. Who owns it? Now, under the facts that I just gave you, the marital homestead is both husband's separate real property. We're going to change the facts in a little bit to see how that changes the answer, if at all. Okay? So the first question is ownership. The second question is occupancy. Irrespective of who owns it, does the surviving spouse or the minor children? I won't ask you about minor children. There never will be minor children on that final exam. But minor children do have an occupancy right, just like the surviving spouse. But I'm not going to ask about that. Does the surviving spouse have any occupancy right, irrespective of what share of ownership he has? And then there's also a question, aside from the occupancy right, aside from the ownership right, is the homestead, that real property that constitutes the homestead, the place where the husband and wife were living immediately before one of them died, survived by the other one, is that exempt from the claims of unsecured creditors? Exempt from the claims of unsecured creditors. Suppose husband ran up a big credit card bill, and then he died. And Visa or MasterCard at $100,000, they want to sell the separate real property. They want to split that constitutes the marital homestead, sell it, and collect that $100,000. Can they sell it, or does wife have the right to occupy it, exempt, free of the claims of those unsecured creditors? Credit card. What's a secured credit? Give me an example of a secured credit. What's an unsecured credit?
Mortgage.
A mortgage on that piece of property, right? Yeah, that's a secured credit. Unsecured creditor, if I run up big debts on my credit card, that's the best example of unsecured credit. There's lots of others, but that's the best example of unsecured credit. Maybe a judgment creditor, that's also an unsecured creditor. It's exempt from the claims of unsecured credit. Three separate issues. First question is, let's figure out who owns this property. The second, can the surviving spouse continue to occupy it? And the third, is it exempt from the claims of husband's unsecured creditors? Indeed, is it exempt from the claims of the surviving spouse's unsecured creditors? All right, ownership we know. We see this nice, easy, simple, straightforward formula for ownership. Now, it's hard, I know. Okay, it's separate real property. So we've already answered in problem 1 the question of ownership. Occupancy rights. What are the surviving spouse's occupancy rights? Where are we going to look for some of the answers to this? I told you where to look. Where would you look? Where would you look if you hadn't been told? Where would you look if you had been told? Where? What? Go ahead. That's chapter what? Look at chapter 102 and look at probate assets, decedent's homestead. Okay. So, what about ownership rights? Look at 00. What did you say? Which one did you say?
3.
Good. Let's look at 03. Let's look at 003 first. The homesteader decedent who dies leaving a surviving spouse. That's what we had here, right? Decedent died leaving a surviving spouse. Descends and vests on the decedent's death in the same manner as other real property of the decedent, and is governed by the same laws of descent and distribution. What is that telling us? Where do we look to find who owns the homestead? You can just tell me general. You don't have to go back and tell me the exact statute numbers. But where do we look? Where do we look? Where would you look if this came up on the final exam in December, as it will? Where would you look? Well, you look at 201.002 in this case, right? The laws of descent and distribution. No, you don't. Where do you look first? You look at the will. That's exactly right. None of this applies if you've got a will. Well, we know by definition we don't have a will because we're doing a test of these statutes first. So if you don't have a will, or if the will doesn't dispose of the homestead for some reason, oh crap. Now we've got to go back into 201.002 in this particular case. That's exactly right. The homestead, if it's separate property of the decedent, what if it was community property of the decedent? And we don't have a will. Where would you look? 201.002. 003, that's exactly right. We're only in 002 because I told you the homestead was a separate real property. It could be community property, in which case you look at 003 and we would have we've already done the answer for what happens if it's community property. Okay. So first thing is we figure out 102.003 tells us ownership rights. That's irrespective of everything else in chapter 102. Figure out the ownership rights first. And 103, you're exactly right. Ms. Gordy tells us just that. Okay. It descends and vests on the decedent's death in the same manner as other real property of the decedent. Okay, so we know that. But now what are the homestead rights? What are the occupancy rights? Oh, and by the way, 002 tells us the homestead rights and respective interests of the surviving spouse and children of the decedent, homestead rights, occupancy rights, and exemption rights are the same whether the homestead was the decedent's separate property or its community property. Okay? That doesn't matter. You'll just be looking in the will, perhaps in a different place, or whatever the will says, or if there's no will, you'll be looking in the intestacy statutes, either 201.002, separate, or 003, community. Okay? But that's only the ownership rights, that's not the occupancy rights. Okay. What are the occupancy rights? Where would we look for the occupancy rights? Or at least for a start on the occupancy rights, there's judicial gloss on this, which we'll talk about in a moment. Where will we look? Remember, we're still in problem 1. Maybe we'll finish problem 1 tonight, maybe we won't. Okay? Again, there's good news. The good news is, come December, when I test you on this heavily, you'll know the answer. And even better news, when the bar examiners test you on this heavily, you'll know the answer, and you'll say, Alton wasn't sure. Thank God he spent this time on it, because I know this answer, and I just smoked this. Okay? That's what I want to have happen. All right. Because they're going to ask you stuff like this on the bar exam, or they might. Often they'll ask you about homestead rights, and you'll know. Okay. All right, so where else do we look? We want to figure out basic occupancy rights. Because, all right, we figured out ownership first. Now we're looking at occupancy rights. Where do we look in chapter 102? Ms. Gordy? You know?
0.005.
Try 0.005 and 0.006, because 05 and 06, it's the same rule, it's just the converse, it's just the flip side, right? Okay. Prohibition on partition of the homestead. The homestead may not be partitioned among the decedent's heirs. Now stop right now. What's the ownership interest? Well, if it's separate real property and we were in 201.002, we know the surviving spouse has only 1/3 life estate, and the children have their share of the 1/3 vested remainder, and then they have their share of the 2/3 fee simple absolute right now. Okay. All right, so the homestead may not be partitioned among the decedent's heirs, they're all co-owners, during the lifetime of the surviving spouse, for as long as the surviving spouse elects to use or occupy the property as a homestead, or if they're minor children, don't worry. I'm not going to ask you about minor children. They're children in the law. I'll let them, family law, I'll let them ask you about minor children. But I'm just going to have a surviving spouse. Never, in all the years I've taught this class, and I've asked about this question a lot, the surviving children are always over the age of majority, so that there aren't minor children, because it also has a guardianship overlay, and I don't want to get into guardianship. That's not this course anymore either. All right, so occupancy rights, it can't be partitioned. That's 005. When can it be partitioned? 006 is the converse. Homestead may be partitioned among the respective owners in the same manner as other property. Who are the respective owners that we're talking about here? Look at 005. May not be partitioned among the heirs. 006, among the respective owners, may be partitioned among the respective owners. Who is that talking about? Who is that talking about? Compared to the language of 005. Same language? No, it's different language. But who do you think that's talking about? The respective owners of the property. It's the heirs, right? In an intestate state, right? Okay, in this situation, it's heirs. In the same manner as other property held in common if, number 1, the 006, the surviving spouse dies, sells his or her interest in the homestead, or elects to no longer use or occupy the property as the homestead. All right, so the surviving spouse has the right to occupy the homestead, irrespective of who owns it. Has the right to occupy it. It can't be partitioned. Has the right to occupy it. It can't be sold out from under dear old mom, or stepmom as the case may be, by the other heirs or the other owners. If there's a will, they are heirs. If there's the other owners of the will. All right, so irrespective of the ownership interest, the surviving spouse has the right to occupy it for the rest of her life, until she dies, or until she decides to abandon it before she dies, or until, it could be a he, right, surviving spouse, or until he or she sells his or her interest. How much are you going to pay her for her one-third life estate? It's not very much, probably. Okay? But maybe she has some other kind of undivided interest. All right. So, occupancy rights. Question about the occupancy rights.
Yes, what would it use to be like not occupying, like if it's a ranch, like a spouse, keep it running and put up the.
Yeah, but it can be partitioned at that point. She's not occupying. So if it's a ranch, if it's an office building, if it's an apartment complex, she can rent it out, and she can make money. And how much money will she get? 1/3 of the rental, because that's what the 1/3 life is. Yeah, exactly right. Okay. But if she's occupying it and chooses to occupy it as her homestead, there's only one homestead. You can only have one homestead. Okay. So if it's a ranch and they have a house in town, they have a ranch. One or the other is going to be the homestead. Okay, it's not going to be both. Okay. And if they're both the separate property of the deceased spouse, I will take the 1/3 life estate if he dies intestate in both of them. But one of them can be partitioned, the one that's not the homestead. The one that is the homestead can't be partitioned. So then the question is, if it can't be partitioned, that's so that the surviving spouse can continue to occupy the homestead. What about the kids? In this example, they own the majority of it. They own 2/3 of the fee simple, and then they own another 1/3 best remainder following her life estate. What rights do the children have to occupy? And concurrent owners. What's the general rule about co-tenants? Each has the right to occupy the whole as long as they don't exclude the other. Can she exclude the kids? And can the kids exclude her? What does the statute say? Well, it doesn't. But there's judicial gloss on the statute. Is the surviving spouse's occupancy rights, you see her occupancy rights, this can't be partitioned during her lifetime. Can the kids say, well, fine, I don't care if it can be partitioned or not. I'm going to move in just like any other concurrent owner. Or if mom gets pissed at the kids, or can mom say, or stepmom say, no, you don't have the right to occupy it with me. Get out. I have the exclusive right to occupy it. Is her right exclusive? Or can they? What does the statute say? Well, it doesn't say anything definite. There's case authority on this in Texas, and the surviving spouse's homestead right, occupancy rights are exclusive. Kids don't have that. And this is one exceptional situation. The normal concurrent owners, normal co-tenancies, normally each would have the right to occupy. So we can only have one homestead. Husband died. He had two pieces of separate real property: the ranch and the house in town. The house in town is the homestead. Surviving spouse, even though she has 1/3 life interest in it because it's separate real property, surviving spouse has the right to occupy exclusively for the rest of her life, but it's a defeasible right. It's like a defeasible life estate. She can occupy it for the rest of her life, but it's defeasible. That occupancy right, exclusive occupancy right, terminates if she sells her interest or if she decides to just abandon the homestead. Why might she abandon the homestead? What? Well, she might get remarried and then she's got the right to occupy it, so the new spouse is surviving, is getting on her right.
Yeah.
Get remarried and what does what?
Move.
Yeah, moves off, decides to move away, right?
Yeah, that's
My
what
new
I mean.
husband, I get remarried and
I
never
always
away.
think you're moving
Okay.
up when you get remarried.
Moving up, okay. Moving on up to the top. That's it. That's good. That's excellent. Okay. So that's it. Okay. All right. She might die. She might decide to abandon, or she might decide to sell it. You're going to pay 1/3. How much are you going to pay for 1/3 life estate? If this is the ownership, not very much, but maybe that's it. So she's got the exclusive right to occupy it, and there are at least 2 Texas cases that hold that. Okay. If you want those cases, I will give them to you after class. So send me an email, and I'll send you the sites.
Can she choose if they have two places, or does it have to be the one she was?
Can she choose? Can she choose if they have 2 places and it might be one or the other? Great question for your marital property class, or file an open records request. Either one. Okay. All right. Yes, there is an extent that she can choose. That's the short answer. Even shorter answer is you don't have to worry about it come December on my final exam. Because when I ask this question, I'm going to make it so clear. This is the house that they were living in immediately before they died, and before the first one died, and The other pieces of property that husband might have owned or the couple might have owned are unimproved lots where they wouldn't have been living, right? I mean, I'm going to make it so clear it's not even funny. You're not going to have to go to that, which you might have to do in your marital property class. You won't have to do that. So I can make it plenty complicated without going that complicated. That's a good question, but I'm not going to go into all that. Okay, what else? All right, so we haven't even gotten to exemptions. Okay.
How does this work if, for example, if an elderly mom or dad and then the kids want to move into the home? Now there's the.
That's a great question for your elder law class. That's well beyond the scope of this class. Don't make me come out there and slap you. No. Just tease them. These are all sorts of good questions that are beyond the scope of the class. And just, if you want to come up, we can talk about it after class a little bit. That's a very complicated answer. This is a slightly simpler answer. This is a complicated answer, but it's well beyond the scope of the class. Okay. Other questions I don't want to answer. All right, now let's talk about exemption. Okay, so you understand the surviving spouse, however it's owned, even if the surviving spouse has no interest in the land for some reason. It's husband's separate property, and so husband dies with a will, saying, I leave everything to my girlfriend Lolita, or I leave everything to my son from my first marriage, or I leave everything to my son, because I never really liked my wife anyway, but it's our beloved son, and it's his husband's separate property, and the son or Lolita takes 100% interest. The surviving spouse has 0. Doesn't matter. She still has an occupancy right that trumps everyone else's rights. Okay? And it's an exclusive occupancy right. We'll get to the exemptions in a second. No. Rent-free. That's a good question. Rent-free. Rent-free. Wow. Okay. Exemption. And it's exempt from the claims of both the decedent's unsecured creditors, the estate's unsecured creditors, and for that matter, the unsecured creditors of the surviving spouse who's occupying. So if I am big mean credit card company and wife runs up a big debt, husband ran up a big debt before he died, I can't attach the homestead to satisfy that debt. If I have a mortgage on it, I can. Right? If I have a legitimate lien on the homestead, yes, I can foreclose on it, but I can't foreclose. It does get paid, but I can't foreclose on it to collect a judgment debt or a credit card debt or any other unsecured debt. Okay, so 3 questions. Okay, first, who owns it? Second, what are the occupancy rights? Exclusive occupancy rights. And you know the surviving spouse has exclusive occupancy rights, regardless of ownership. And you also know that it is exempt from the claims of unsecured creditors of the decedent's estate or the surviving spouse. Okay.
The exemption lasts beyond the
Surviving spouse's lifetime?
Yeah.
No. Okay. The exemption only, and that's a really good question, and if we have time when I get to chapter 10 toward the end of the semester, and often I don't have time, so if I don't have time, I won't ask you that on the final exam, but it's a good question because it might come up on the bar exam, or definitely comes up in real life. Exemptions. Homestead is exempt from the claims of unsecured creditors. You have to have someone still living to claim it as a homestead. If the surviving spouse or it's minor children occupying it under a court order with the guardian that I've just ignored. If there are no minor children and there's no surviving spouse, then there's no one to claim a homestead exemption. And it's not exempt from the claims of unsecured creditors of the decedent. Credit card company can get it. And the priorities, and we'll talk about priorities later, between secured creditors and unsecured creditors, but assuming that there's an interest rate. That, because no one will have occupancy, right? Okay. All right. Let's see what else I want to say about this. So, again, let me reiterate this, a couple of important points here. Okay? Don't confuse the homestead occupancy rights with the, say, the surviving spouse, with ownership, with title to the real property that constitutes the homestead. Okay? Just keep those things separate. Ask yourself one first, who owns it? And you know that answer because it'll be found in the will if there is one. They have to figure out whether it's separate or community property to see whether they're passing all of it or saying that anybody's going to have it. And if there's no will, then we go back to the intestacy. One, ownership. Number 2, exclusive occupancy rights. The surviving spouse has exclusive right to occupy it as long as she lives or until she abandons it. She does that until she dies. We know she's going to abandon it when she dies, right? She goes out to be first, that's it. Okay? But if she's still alive, if she walks out of there or gets wheeled out of there, then, and abandons it, has an intent to abandon the homestead, then the occupancy rights terminate, or if she sells her interest, he or she sells his or her interest, then the occupancy rights terminate. And finally, is it exempt from the claims of unsecured creditors? Yes, if the surviving spouse is exempt from the claims of both spouses deceased, and the surviving spouse's unsecured creditors, the not secured creditors, not those who have a security interest in the homestead, mortgage on the homestead, or some other thing. Right, I want to emphasize one other common mistake. I've tried to emphasize this again and again and again. Ownership. Let's go back to ownership of the homestead. Look first in the will, and secondly, there is no will, look under the intestacy statute. And remember, don't assume that we are in 201.002. It's only there if the homestead is the separate real property of the deceased. If it's community property, we're in 003, right? So don't, I mean, what students will do on an exam, and it's wrong, is assume this is the way the homestead is owned. No, this is the way separate real property is owned. Homestead might be community property. So we might, if we, first off, we have a will, then how's the homestead owned? If there's no will, then we're in 201, 002, or 003. 002 if it's separate real property, 003 if it's community property, right? Okay. Let's see what else. I think that's probably it. I think I've beaten problem 1 to a bloody pulp. Question, beating that dead horse, there are flies around. There are maggots. I mean, the flies have okay, all right, I'll stop with that image. Any other questions about problem number 1? That's a lot. I told you there's going to be a lot in problem number 1. You do almost the whole course in problem number 1. You can do almost the whole final exam in problem number 1. I won't, but I will ask you a number of questions on a final exam that have been generated from problem number 1, and then also from the rest of the problems in these intestines. Any questions about that? All right, let's look at problem 1A and 1B. What's the difference in problem 1A? Does the referee want to do it? You don't have to if you don't want to. But we can move on to someone else. I'm happy to move on to
It's a
someone else.
long row.
It's a long row. And it's a long night, isn't it? Actually, it's not a very long night. We only have another 21 minutes. Okay. Anyone want to do 1A? Problem 1A. What's the difference between facts between 1A and 1B? And we won't go through all the homestead rights. You know them now. But we will go through the ownership rights. What's the difference between 1A and, between problem 1 and 1A? And then we'll see the difference between 1A and 1B. What's the difference between the facts? It's like what? The children are from a previous spouse in 1A. All of these children are from a previous spouse. How will that change? So my question is, how does that change the ownership interest, the distribution upon intestacy? Father dies, survived by a surviving spouse, and all 3 children, and they're all 3 her stepchildren. None of them are her blood children, they're all 3 her stepchildren. What's the ownership? How does that change the answer between 1A, 1 and 1A? How does that change in terms of the separate property, real and personal property? What was the answer? Does it change it at all? Doesn't change it one whit. The same sections 201.002, subsection B, in problem 1A and problem 1, same ownership of separate real property and separate personal property. Separate property hasn't changed. The community property has. Okay? All right, where are we? Let's go back to, I'm going back, I'm flipping back here. Look, where are we in 201.003 in problem 1A? We're in which section, which subsection? C. We're in subsection C. Before we were in subsection B. In problem 1, we were in subsection B because all those children were also her children. Okay? C. If the deceased spouse is survived by a child or other descendant who is not also a child or descendant of the surviving spouse, that's what we have in problem 1A. All of them aren't. None of them are. All of them are. None of them are, right? None of them are also her children. They were her stepchildren. They were related by affinity, by marriage, not consanguinity, not blood. They're not hers. Then, what happens? One half of the community estate is retained by the surviving spouse. Stop right there. One half is retained by the surviving spouse. A waste of good ink. I don't need this statute to tell me that. She owns it anyway. Surviving spouse, that was hers because death dissolves the marriage, dissolves the community. That doesn't. She keeps her one half because she owned it already, not by descent and distribution, not by intestacy. Okay? And one half of the community estate, whose half of the community estate is that? That's the decedent's, right? These half of the community estate. I'm sorry. Oh, and the other one half. I'm sorry. The other one half passes to the deceased spouses, not the surviving spouse, in our example, husbands, children, or descendants. Okay? That's the surviving children or the surviving descendants of any predeceased child, right? So, where does the community property go here? In problem 1A, surviving spouse. How do we divide all the community property? All the community property. What's her share of the community property? 1/2. Any difference between real property and community personal property? No. And then C1 through C3 take the other half, don't they? They don't take half that half, they take all of that half. Their dad's one half, and how is that divided? There are three of them. Each takes 1/3 times that 1/2, or 1/6 of the community property. End up with surviving spouse 1/2. Each one has 1/6. What if the community property, if the homestead was community property? How would it be owned? Surviving spouse would have 1/2, and each of the children would have 1/6. Could they partition it? No. Does she have an exclusive right to occupy it? Yes. We've been through all that before. Okay, but it wouldn't be that answer. That's the answer if the homestead is separate real property, community property, or this community. Okay? Question about 1B. Does it make any difference if his parents or siblings are still alive? 1B? No, it doesn't make any difference. Okay, 1A. I'm sorry, we're in 1A. We're not 1B. 1A. Now, 1B. The difference in 1B is that child 1 and 2, 1B. I'm going to erase the separate property because 1B, 1A and 1B, the separate property answer is the same as number 1. Right? It's only community property. All right, so in 1B, it's child 3 is theirs, right? Child 1 and 2 is not theirs. Is that right? Yeah. So child 1 and 2 were stepchildren of hers. Child 3 is her child. And the child 2 of them have together. How does that change the answer, and how does that change the distribution? I want to talk about that. It doesn't change the separate property at all, but we're going to see what it does to community property. What's the relationship between child 1 and 2 on the one hand and child 3 on the other? They're half-blooded. That's exactly right. They're half-blooded. Does that make any difference in the share that they get? No, it doesn't. We'll see what half-blooded heirs takes up the difference. But what's their relationship? What's 1 and 2's relationship to dad? Is it a half-blooded child? What's 3's relationship to dad? Half-blooded children. They're half-blooded siblings. They're half-blooded each other. We're not distributing the siblings' estates into that. We're distributing dad's estate. Okay? 1 and 2 are the stepchildren of the surviving spouse. Stepmom. We're not distributing her estate either. We're distributing dad's estate. All three of these children are equally related. So, now, 201.003, subsection. We're still in subsection C, right? If the deceased spouse is survived by a child or other descendant who is not also a child of the decedent, that's 1 and 2. It is just in 1. Okay? Any of them. In problem 1A, it was all of them. In problem 1B, it's some of them, but not all of them. Some are also hers. How do we divide it? We divide it the same way. So, surviving spouse takes in problem B. Surviving spouse keeps her 1/2. Each takes none of her husband's one half, and how's that distributed? Is it the same as 1A, or is it different than 1A? Is 1B, is this distribution in 1B different, or is it the same? Statute doesn't make it different. Okay? Therefore, it is the same. There's no change in 1B and 1A. And when I was walking around the other night, a couple of people were asking me this. I said, don't forget this job. Sometimes students make one of two mistakes on a problem like 1B. When some, but not all, of the children are stepchildren of the surviving spouse. All were equally rated dad. So they all each take an equal share. Now, if any of them were dad's stepchildren, they don't take a share. They're not his heirs. Steps aren't his heirs. We're not distributing her estate. We're distributing his estate. All three of these children are his children. Don't leave any of them out. Two most common mistakes is students will give one on the final exam, bless you, 1 and 2, child 1 and 2, everything, and leave child 3 out. Other mistake, they'll give child 3 everything and leave 1 and 2 out. Don't leave them out. They're all equally related to dad. They're all dad's children, not dad's stepchildren. They're 1 and 2 are mom's stepchildren, but not distributing mom's stepchildren. Question about that? Straightforward. I know. You think I am beating this dead horse. Just as I continue to flog this horrible, maggot-infested, bloated, awful, smelly, rotten dead horse. Even those of you who like horse meat would not eat this carcass. I understand that. But I'm doing it for a purpose. Please, as I say, make a liar out of me. Be the first class who doesn't miss any of this stuff. I spend this amount of time because I've been doing this course for, 10, 12 years now, maybe almost 15 years now. And someone misses it every year. Some years, 3 or 4 or 5 people, 8 or 10 or 12 people. Some years, 40 people miss it. Of course, that's when I have a class of 90 or 100. You're a smaller class, so I hope none of you miss it because I have, say, invested this amount of time in this. Okay. No questions on this? Let's do 2, 3, and 4. And when we do 2, 3, and 4, then I want to break into small groups and do 5 through 11. We won't have time to do that. So I'll do 2, 3, and 4, and then if I have 5 minutes, I'll let you out 5 minutes early. And then those of you who have me before, you know what I'm going to do. Yeah, that's right. You're saying you're going, I'll let you out 5 minutes early, but someday I'm going to keep you 5 minutes late. I'm going to say we're even, okay? Or I'll keep you 1 minute late for 5 nights, and then I'll say we're even. Okay, all right. Because I guess that'll happen. All right. How about problem 2? And by the way, my notes used to say what happened under prior law prior to 1991. 93, I'm not going to ask for that. Okay. But if you're doing title searches, you'll have to know what the old law. Community property is distributed a little differently under the old law. Problem number 2, there are no surviving descendants of the decedent. All these people have died, the children, the grandchildren have died. There is only a surviving spouse. Let's do problem 2. Let me first off see if I've got a volunteer for problem 2. And fair warning, I'm going to throw a hypo or twist at you immediately. Any volunteers? Otherwise, I'll make a volunteer. All right, thank you. All right, volunteer for problem 2. Okay, in problem 2, it's easy. There's only a surviving spouse. All these other people are dead, right? Only a surviving spouse. So let me ask you this. What if the surviving spouse has a child from a prior marriage who's not also the descendant of the decedent who died first? The decedent has died by a surviving spouse, and the surviving spouse's child from a prior marriage or from an affair or out of wedlock that wasn't the decedent's child. Does that going to change your answer at all? If not, why not? You're exactly right, it won't. Because what would that child be? What would the relationship of that child be with the decedent? It would have been a stepchild. That's exactly right. Or step-grandchild, or step-great-grandchild, or step-descendant. And steps are not heirs. They don't take. How do we know that steps don't take, by the way? You know how we know that steps don't take?
There is no actual legal relation between the two.
That's right. There's no actual legal relation. But I'm going to tell you that in some states, in a handful of states, steps do take under intestacy in certain instances. But they don't in Texas. You're right. They don't in Texas. How do we know that? What's your authority for that?
I don't know exactly, but I mean, it's the family code.
It's really the estate code. Where would it be? Where would we find it? Where would we not find it? Yes. You're kind of on the right track. I mean, you're not on the wrong track. But it is in the estate code. Or it's not in the estate code. If it's anywhere, it's in the estate code. How do we know who the heirs are? How do we know who the heirs are? Where do we look to see who the heirs are? Where do we look? Chapter 201, 001, 002, and 003. And if you read all those and read carefully, those statutes, you've already seen it. Easy, simple, and straightforward to read. No, they're not. They're hard. I know they're hard. Okay? But where does it say the steps take? It doesn't say the steps take. And no one takes. It doesn't say in the statute. Steps are not heirs because they're not there. And when we go through all of 001, you'll see steps aren't in there anywhere. Okay? So, this way, you're exactly right. You are exactly right. If we change the facts in problem number 2 and say that surviving spouse had a child or grandchild from a prior marriage, or a liaison outside marriage, or whatever, that's a step to the decedent, and that would change the answer because they're not there. So in problem number 2, the surviving spouse is the only heir. Okay? What about where does the community property go in problem number 2? Okay, community property, number 2. Community property, and then separate property. That's right. The surviving spouse keeps her 1/2 and takes 100% of her husband's 1/2. So the surviving spouse ends up with 100% of community property. Her 1/2 because she already owned it, and his 1/2 because can you prove that to me? Can you show me in 003 where it says that the surviving spouse takes 100% of it if there are no surviving descendants? It is exactly B1. The community estate of the deceased spouse. The community estate of the deceased spouse. That's husband's 1/2. That's decedent's 1/2. Passes to the surviving spouse. All of it. 100% of it. If no child or descendant of the deceased spouse, of D, survives the deceased spouse. That's what we have in problem number 2. So, community property, surviving spouse keeps her 1/2 and takes 100% of his half. Half and half are 100%. All right, very good. Excellent. How about the separate property? We have to make a distinction between the separate personal property and the separate real property. Where are we? We're back in 201.002, and we're in subsections what? All right, C1 is going to be for the personal property. Where does the personal property go? Does the exceptions provided by subsection D? We know we're going to have to look somewhere else, too, to make sure that it doesn't screw up our answer here. If the person, that's D, the decedent, the intestate decedent, has no child and no descendant of the child that survives him, then the surviving spouse is entitled to all of the personal estate. Separate property, separate personal property goes to surviving spouse 100%. What about separate real property? That is subsection 2 and 3, right? Okay. Surviving spouse entitled to 1/2 of the person's land, 1/2 of the decedent's land, separate land, right? Without a remainder to any person. What does remainder mean there? Does it mean balance, or does it mean? No, I think it actually means a remainder in that case. It means, in other words, outright, in fee simple, not a life estate. It really does mean remainder at that point. So, the surviving spouse gets 50%, 1/2, in fee simple absolute. There's no remainder. It's not merely a life estate. It's followed by a remainder. I think it means, isn't that great that they use the word remainder in that same statute, subsection B and subsection C? I think in 2 damn different sentences. Who wrote these statutes? What clown wrote this statute? Oh, that's right. It's the legislature. Okay. All right. Surviving spouse gets 50% in fee simple absolute of the real property, and then where does the rest of that go?
The other half goes according to the rules.
Crap, the rules of descent and distribution, where will we find those? Rules of descent and distribution, where will we find those? No, not in the Constitution. What? 201 what? Not 101. 201-001. That's exactly right. Where are the statutes of descent and distribution? We're in them, ladies and gentlemen. This is a circular reference, but it must not mean, according to 201.003's community estate, we already know we're in separate estate. 201.002 subsection C3 says we've got to look outside this statute. Where are we left with? 001. Okay. And 001 subsection B. So they're children. We already know we don't have any children. Subsection C. Just the parents. Subsection D, if only one parent survives but they're siblings. We're not siblings. Subsection E, if the parents aren't surviving and there are siblings. So we're in C, D, E. Are we in F and G? Look at subsection D. 201.002 subsection D. The subsection C already told us that F is provided by subsection D. Subsection D says, if the person described by subsection C, well, that's the rules of the heirs of descent and distribution, 201.001. If that person does, the person described by subsection C, that's the deceased. I'm sorry, that's the deceased. That's the deceased. Does not leave a surviving parent or one or more surviving siblings or their descendants, then the surviving spouse is entitled to the entire estate. We already knew she took the whole personal property estate. We knew under subsection C, she took 1/2 in fee simple of the real property. She's entitled to the other 1/2 according to subsection D. The surviving spouse takes the other 1/2, that is all of it, of the real property in fee simple absolute. If what? If the decedent, the intestate decedent, this is the husband, didn't have surviving parents or siblings or descendants of siblings, or the descendants of siblings also descendants of the parents. Yeah, they are also the descendants of the parents too. Right? So in other words, they don't have surviving parents or any descendants of the parents. The siblings would be descendants of the parents. Then, in other words, C3 says, back up to C3, 201.002 C3, passed according to the rules of descent and is inherited according to the rules of descent and distribution. We have to look in 201.001 C, D, and E, but no further than that. Not any further than that. That's as far as we go. Problem 2. Does it make any difference in our answer if the decedent left surviving parents or siblings or descendants of siblings? Yes. Problem number 2 is the only situation where that makes a difference in how the separate, if some of these states distributed. In this case, it's a separate real property. I thought I was going to let you out earlier. I'm not going to let you out earlier. But I'm not going to keep you till problems 3 and 4. We're just about out of time. Isn't this easy? Isn't this simple? Okay, I know it's hard. I know it's hard. But I got to separate the A's from the B's from the C's somehow. You know that, right? Okay. Yes, question?
The surviving spouse, which one of them 100%?
100%. If the decedent left no parents or siblings or descendants of siblings. That's, you got to know that additional. Okay. We've got more questions. Come on up. I'll stand around and answer your questions. On Thursday night, we'll finish problems 3 and 4 pretty fast now. We really will finish 3 and 4 fast. I promise it won't take long. Then we'll break in small groups, do problems 5 through 11. And we'll do problems 5 through 11, and then we'll break into smaller groups, do problems 12 through 19, and maybe we'll start that on Thursday night. We're not getting as far as I thought we were going to get. We're not going to get into assignment 2. We'll be lucky to finish assignment 1 on Thursday. We'll finish that next Tuesday. So, all right? Great. See you in just under 48 hours. Come on up if you got questions. Yeah. Yeah, haircut, boy. Yes. You got a haircut. Yeah, I think it was good. I like it. No, it's right. It's sometimes I get
Oh my God, I know. That was hilarious. How did you do? Oh my God, the entire last year, Jack always was there. I had no idea. Like I was really judging, and then I was on to something else.
Yeah. And that's what was funny, you were saying that, you know, not exactly the same way. We were talking before, so I was about to write, I'm gonna be on the director of the
We all are.
We all are. No, but I'm kind of really excited about it. Yeah. I mean, what we were talking before, and all, we got all everything.
Yeah, yeah. And if you what he puts up there, again, there's enough people that get this.
Yeah. Like, okay, so far we're in like 8 range.
Then I'll come down to speeds.
Yeah. Well, I thought we did pretty good on speed considering.
And if you know it, off the top of your head, not like that's where, evidently I thought I did wrong.
Yeah.
I got a bad grade. There was some first year. No, not first year. There was so much. It was impossible. Oh, sorry.
No hay problema.
All right. Send me email, please.
Relaxing, not taxing.
No. It needs to go
Well, stop. Automatically
Their share is only, their share is 2/3 simple.
And I love that when we're out, that's how like, I feel like, my vision is just like when I was young, I haven't had that in a long time. How about you?
They keep it nice. That's why they.
You know, like, I remember the history.
It's very rhythmic.
It is, and that's what I grew up around. Even though our family didn't speak it, I was around that sound, and it sort of like gives you
Oh, did I say
vibe, and it makes you be a little bit more fun and relaxed. You can't really be uptight. You can't really be uptight in Mexico. And you know, not around those people, not around that bohemian kind of.
Yeah.
Oh,